Live from Washington, D.C., Jay Sekulow Live. Phone lines are open for your questions right now. And now, your host, Jordan Sekulow.
Two major cases out of the Supreme Court today, both 5-4 decisions. So just, again, 5-4, same justices in each that made up the majority and the dissenters. In the case, again, we were involved in both of these cases. On the pro-life case, these were the pro-life pregnancy centers. Some call them crisis pregnancy centers. This was a case out of California. We also have one out of Hawaii that will be affected by this, and we'll talk about this later in the show with our team of experts and attorneys who have been working on this. In that case, we filed suit against the state of California on behalf of 3 licensed pro-life pregnancy centers before the law went into effect. Eventually, the Ninth Circuit did affirm this law, and Trump versus Hawaii. They love to call it the travel ban. In fact, the president is going to speak on this very soon. The decision of the court was written by Chief Justice John Roberts, 5-4, in favor of the president having the power under both presidential power and existing law to put together this enhanced vetting capability. Let me go first to Harry Hutchinson. Harry, the justices here, Chief Justice Roberts, very clear that the president had the authority, and this was a case that went all the way. I mean, it was a tough haul for the Department of Justice and the president. I said it throughout the time. I thought once it got to the U.S. Supreme Court, that you would get some minds on this. It would get less political, and they'd go to the law, and the law is pretty clear. Now, ended up being 5-4,
Absolutely.
but that is a victory.
Absolutely. And so I would say your intuition is absolutely correct. That when you review this policy, the enhanced vetting policy dispassionately, consistent with the U.S. Constitution, consistent with the Immigration and Naturalization Act, the president has broad discretion to do virtually everything possible to ensure national security. This policy was ultimately vindicated, despite claims that the policy violated the Establishment Clause or it violated the so-called non-discriminatory provisions with respect to visa applications. The president clearly has this authority. Now, it's also equally clear that many of the opponents of this policy will continue to claim that this policy violates the Establishment Clause and his statutory authority, but it's all part of the Trump derangement syndrome. It's all part of the resistance.
This was probably the most politically charged case that was going to come down from the Supreme Court. Think about how many times we fought for the president's ability and for our government's ability to put together this list of nations and people from those nations that we felt posed a serious security risk to our country. And so with enhanced vetting, they may be able to come, they might not be able to come. And so some of these countries, by the way, worked themselves off the list. Folks, there's a lot more to discuss about these cases when we come back from the break. This morning, as we were preparing the broadcast, so you're watching how these opinions come out now digitally. You will have, it could be people like Shannon Bream on Fox News coming down with the opinion. There's also websites like one is called SCOTUS blog, where people go in and out and basically are live blogging the opinions. What you're really looking for today is you knew these cases were coming either today or tomorrow. Would they put two of the most high-profile cases together? So when the first case came out, it was the pro-life pregnancy centers case that we spent the first half hour on. So everybody thought, okay, when that came out, it must be that the travel ban case or the enhanced vetting case, that's got to be tomorrow because they're not going to put those two out on the same day. And lo and behold, seconds later, they've put out that case as well. both 5-4 decisions. The enhanced vetting case was the majority opinion written by Chief Justice John Roberts. What it does, let me remind people what this does. It was back in September of 2017. The president issued his third executive order on immigration titled Enhancing Vetting Capabilities and Processes for Detecting Attempted Entry into the United States by Terrorists or Other Public Safety Threats. The order was set to go into effect on October 18th, and unlike the others, was permanent. At this moment, the order was blocked. Of course, both these cases, interesting today, came out of the Ninth Circuit, which was reversed. What did it do? It halted immigration from 8 countries: Chad, Iran, Syria, Libya, Somalia, North Korea, Venezuela, and Yemen. Sudan and Iraq used to be on that list, but worked themselves off of it by working with the U.S. government on enhanced vetting and getting the right information to them. It no longer addressed the refugees issue because that one had a time period that had lapsed, you may recall. It was under a section of the Immigration Nationality Act, 1182F, that allows the president to the broad discretion to suspend the entry of aliens into the U.S., and it's just major deference to the president as well. The prerequisite is that set forth in 1182F is that the president finds that the entry of the covered aliens, and this is all it has to be, would be detrimental to the interest of the United States. So the Supreme Court has said the president did that here. And Harry, they said the president did that here by working with different federal agencies, putting together the list comprehensively, working with the Department of Homeland Security, working with the State Department, working with the list of those countries that Congress had identified, that previous administrations had identified, working with all those different agencies. He did just that. He put together a comprehensive evaluation and figured out which ones would be detrimental to the interest of the United States. It wasn't just, oh, they're a Muslim country, because if they were, there'd be a lot more countries on this list.
Absolutely. So I think your analysis is spot on. The president complied with his statutory authority under Section 1182F. First, what did he do? He ordered a review, and so the DHS conducted a comprehensive evaluation of every single country's compliance with the information and risk assessment baseline decided on by DHS. Is there, for instance, any additional evidence that the president complied with his statutory authority? Absolutely. When he issued the proclamation, he issued the proclamation with extensive findings about the deficiencies of countries in terms of their compliance with our requirements. And so the restrictions on aliens was grounded in the failure of their own home countries. Thirdly, he issued a 12-page proclamation which was more detailed than any prior order issued under Section 1182F. So thus, the plaintiff's claim that searching inquiry is required is nonsensical. Why? Because the president complied with every statutory provision, and in addition to all of that, the Supreme Court announced again, which should be self-evident if you read the Constitution, that the president has broad authority to protect us. Clearly, the president complied. The huge disappointment that I have with respect to the opinion is the fact that it was only 5-4. This means that at least 4 justices cannot read either the statutory language or the Constitution properly.
Yeah, I mean, we've got a caller who is upset about that as well. Chris in Nevada Online 6. Chris, welcome to Jay Sekulow Live. You're on the air.
Hi. It was a great day, and I'm disappointed but not surprised they were 5-4 decisions. Having said that, what's the remand involved?
The remand on all these cases, you've got to go back, and the lower courts have got to then put in place the order, the holding of the Supreme Court, as it relates to the specific cases.
Absolutely. So essentially, this means that the lower courts need to throw out their own judgments, and it means that the president is empowered from this day forward to actually fully implement the travel ban, which was really on hold. But now he can fully implement it. And I also believe that this means that the president can amend, can add to the enhanced vetting procedures that he has in place already.
Yeah, I mean, the court said that, it implies that this is temporary because you're talking about covered aliens that would be detrimental to the interests of the United States maybe for a period of time, but that the president doesn't have to put a timestamp on that. And so some could be there longer, some could be there shorter periods of time as well. And again, I think, and we did get a question from Christine, can the lower courts override the Supreme Court decision? No, they cannot. So they once the Supreme Court speaks, that is it. There are ways you can try to challenge Supreme Court cases by kind of coming up with novel and new approaches in new cases, but it's not by lower courts cannot get involved here. All they can do is follow the precedent of the Supreme Court of the United States. And it was two separate victories. For those of us, the ACLJ, very important. But what it means to get these kind of victories in one day.
Well, I mean, I think it's huge that we do have them, and that they both came on the same day. One, a victory for the free speech of the people of the United States and the lack of the ability of the government to tell us what to say, who to say it to, how to say it, when to say it, what to say it. That's now not going to happen, especially in the context of these abortion clinics and the pro-life pregnancy centers. And with respect to the travel ban, the travel vetting and enhanced act that the president, the proclamation the president has entered into, it's a victory, I think, for national security, for the right of the president to make these decisions under the Immigration and Nationality Act. And I think it's terribly important that we have this. I regret that it's 5-4. I thought it would be better. But sometimes these justices who are on the hard left are just not going to get it. And by what I mean not getting it, they don't know how to read the Constitution.
We have cases like them around the country that'll be impacted because of the Supreme Court decisions today. Folks, there's a lot more to discuss about these cases when we come back from the break. Welcome back to Jay Sekulow Live. This is Jordan Sekulow. We just got this statement in from the White House, the President of the United States, regarding the Supreme Court ruling. And this is from President Trump. Today's Supreme Court ruling is a tremendous victory for the American people and the Constitution. The Supreme Court has upheld the clear authority of the President to defend the national security of the United States. In this era of worldwide terrorism and extremist movements bent on harming innocent civilians, we must properly vet those coming into our country. This ruling is also a moment of profound vindication following months of hysterical commentary from the media and Democratic politicians who refuse to do what it takes to secure our border and our country. As long as I am president, I will defend the sovereignty, safety, and security of the American people and fight for an immigration system that serves the national interest of the United States and its citizens. Our country will always be safe, secure, and protected on my watch. A very strong statement from the President of the United States just now. And Andy and Harry, let me go to both of you. Did not shy away from going right to the immigration issue as well on this and saying it's the hysterics from the Democrats, from the media, and that's the reason why, though he can go as far as he can through this kind of executive order, that it comes to immigration and national security concerns on immigration, that's going to take, again, some Democrats and politicians and the media not freaking out so much.
Absolutely. So if we focus for the moment on the hysterical claims made by the opponents of enhanced vetting, one of their claims was grounded in alleged religious discrimination. So they offered really two bases for religious discrimination claims. First, a statutory basis. So they focused on Section 1152A1A. Basically, it's a non-discriminatory provision or a non-discrimination provision that affects visa applications. However, they fail to look at the universe, and Section 1182F refers to the universe of aliens who are applying for entry into the United States. So you first have to decide whether the president had sufficient statutory authority under 1182F. He clearly did, and he exercised that authority. The second religious discrimination claim was grounded in an alleged violation of what? The Establishment Clause of the United States Constitution. And it is clear beyond question that there was indeed no violation of the Establishment Clause, notwithstanding the hysterical claims made by opponents of enhanced vetting. The president exercised his authority consistent with national security. That's number one. And then number two, even the enhanced vetting, if you took it outside of the parameters of the Constitution for a moment, which you cannot do, of course, clearly he also had clear authority, and the president said, we will not look beyond the four corners of the proclamation to find religious animus. He had the authority based on the facial validity of the travel ban. His authority was upheld, and I think clearly that's the right answer.
Sarah on Periscope wrote, what a strong statement from the president. I agree. I mean, I think just that sentence, this ruling being a profound vindication following months of hysterical commentary from the media and Democrat politicians who refuse to do what it takes to secure our border and our country. So he did what he could as president, going as far as he could through executive order. We've also got another Periscope comment coming in. And Andy, this again about confirming judges, that would we not maybe be in this situation if we had more judges confirmed to these different circuit courts, and if that was sped up, if we had more judges, maybe more viewpoints, that there wouldn't have to be these controversial cases always determined by the Supreme Court.
That's right, and I think the appointment of conservative, and by conservative judges, Jordan, I want simply judges who know how to read the Constitution.
Yeah.
As Justice Kennedy said in his concurring opinion, the way that you approach this is you read the First Amendment as it was adopted in 1791. That's all you need to do. I agree with what Justice Scalia said. The Constitution is a static document. It was written in the 18th century. You read the language as it says, and then you're okay. It's all these glosses that these liberal judges put on it. Sotomayor, for instance, Justice Sotomayor, she takes this thing as I feel and I think and I believe and I project, and therefore that's what my opinion is. That's not what you're there for to do. That's not the purpose in your function as a judge. It's to read the clear language of the Constitution and the statute. And another thing, one of the things here was this guessing game of what the president said while during the campaign with respect to Muslims. And we said in our brief, the legality of proclamations or executive orders related to immigration does not turn on a judicial guessing game of what the president's objectives, motives were at the time the order was issued. If it is facially consistent with the INA and the Constitution, and there is no reason to doubt that this was not, then it's valid.
Yeah, I mean, this is, again, I think it speaks to the heart of the need for, when we talk about conservative judges, it's not necessarily, you can always predict exactly how they'll come down. In fact, it's the liberal judges that I can usually look at and say, okay, I know exactly how they're going to rule on these issues. Now, it's interesting, Harry, because now we've got a Republican, though, maybe one in name only, Jeff Flake, and he's actually threatening to block judges now. This is part of his whole deal, I think, trying to get attention, that he is going to stand in the way of judicial nominees. I think we may focus on this more tomorrow with Than Bennett, but that is so detrimental, as you talked about, this idea that we're playing politics with the judiciary, and that is, again, the Senate has a role in advise and consent. That's a pretty limited role, but they have made it one where they are the ultimate gatekeeper, not the president who makes the nomination.
So I think the conservative voters should vote to make sure that actual Republicans are elected. as opposed to individuals who claim to be Republican, and essentially they are Republican in name only. That is one of the quintessential problems in American politics today, the ability of politicians to play games, and I think Senator Flake is a classic illustration of that.
2 major victories at the U.S. Supreme Court. The president absolutely vindicated, and presidential power vindicated by the Supreme Court's decision on enhanced vetting on those specific countries listed by the president to prevent immigration for a period of time. The Supreme Court held that that was a constitutional use of the president's authority. We have blogs on both of these cases up. Folks, today was a great example of how the work of the ACLJ really matters all the way up to the U.S. Supreme Court. And we were involved in both of these cases. As we finish out the show today, I hope we provided a lot of information for you about these 2 major cases out of the U.S. Supreme Court. We want to thank TBN for allowing us to bring this broadcast to you at no cost to the ACLJ. So each week we're able to update you about these important cases or issues happening here in the United States and around the world. It's because of TBN that we're able to bring this broadcast to you at no cost. So thank you, TBN, and we will see you next week.